SwayamPrabha. Digital India. Educated India.
Hello viewers, Namaskar and welcome to SwayamPrabha. I am Professor Vageshwari Deswal and I, along with my colleague Dr. Saurabh Rana, will be delivering a 20-hour course on the procedural law related to crimes in India, which is the Bharatiya Nagarik Suraksha Sanhita 2023. So first of all, let me give you an overview of the criminal procedural system in India. So let us understand what is procedural law. So viewers, there are two types of criminal laws mainly. One is the substantive law and the other one is the procedural law. The substantive law is one that lays down the substance of any crime. It lays down what are the essential ingredients of a crime, and at the same time the substantive law also prescribes what are the conditions that make an accused eligible for exemption from criminal liability. So once the law is firmly established that what constitutes a crime, the next step is, suppose somebody does that act which has been forbidden under the law. So now either the state may itself take cognizance of the same, or someone might go and either register an FIR or a complaint and ask the state action to take action against the accused who has committed the crime. Now how is the state supposed to proceed through its agencies? Like how are we supposed to apprehend or arrest the person who has been accused of a crime? How are we supposed to investigate the offence against that person? Then how do we collect evidences? How do we conduct a trial? How punishment is to be awarded? How that punishment is to be enforced? Now all these things have been dealt with under the procedural law related to crimes in India. So when we were given the first substantive law related to crimes, which was the Indian Penal Code, which was enacted by Britishers way back in the year 1860. So immediately after that they gave us a procedural code also. But after we got our independence, we realized that the old law was enacted by our colonial masters, and due to that the constitutional guarantees that our constitution guarantees to each and every one of us, they were overlooked in that old procedural law. So we drafted a new criminal procedure code to suit the ethos of our people, and one which was in conformity with the constitutional provisions. So that attempt which was done and the procedural law which was enacted was the Criminal Procedure Code, which was enacted in the year 1973. Now that procedural code had 37 chapters, 484 sections, and additionally it had 2 schedules as well. Now, in the year 2023, that law has also been removed, and now we have a new procedural law, which is the Bharatiya Nagarik Suraksha Sanhita 2023, which is enforced from 1st of July 2024. Now, this new Sanhita, it consists of 39 chapters, 531 sections, and has 2 schedules appended to that. First of all, let us decode the title. From Criminal Procedure Code to Bharatiya Nagarik Suraksha Sanhita. So when we talk about the Criminal Procedure Code, the meaning is clear. It says a law which lays down the procedure to deal with crimes. But see, in a democratic society, a country that boasts of being a welfare state, it is not merely implementation of the procedure that is important in criminal cases. What is important is that the law needs to inspire confidence amongst its people. People should feel secure that, see, there is a procedural law in place due to which any kind of crime that is about to be committed, sometimes there could be a preventive detention that might be required, and if at all a crime has been committed, the accused would not be able to escape. There has to be a fear of breaking the law in the minds of criminal minded people, and those who are law abiding citizens, they should have a sense of security. And then there is another category of people, those who sometimes on the spur of the moment they commit a crime. They are not hardened criminals. So such people who have committed petty offences or who are first time offenders, now we need to give them a second chance. They have to be penalized, but at the same time we have to be mindful of the fact that we should not be isolating them from the system so as to rather transform them into hardened criminals. We are supposed to keep them within the fold of the society and try to enforce the objective of our punishment system. That is, what is the objective of punishment in India? Reformation. So we have to try to reform, rehabilitate and reintegrate petty offenders back into our system. So that is why from a simple procedural code, something which was not taking into consideration all these things, now we have evolved into a law which is Bharatiya Nagarik Suraksha Sanhita. So this is a law which has more of a citizen centric approach, and what is the objective of this Sanhita? The objective is Suraksha, that is protection. So now instead of being merely procedure based, what do we have? We have a law which is protection based. Now, why did we need to replace the old CRPC with BNSS 2023? See, CRPC 1973, it was not enacted by our colonial masters. It was enacted by us for our people. So then why did we need to overhaul that law and bring in the new procedural law code which is more focused towards protecting our citizens? The need was, first, we all know that justice delayed is justice denied. So fast and efficient justice system is an essential component of good governance. However, delay in delivery of justice due to complex legal procedures, huge pendency of cases in courts, low rate of conviction, insufficient use of technology in legal system, delays in the investigation process, inadequate use of forensics. Now these are some of the biggest hurdles in speedy delivery of justice. And who is the most affected by all this? The most adversely affected by delay in litigation is the poor man, because as the litigation goes on, costs they keep on mounting. You have to pay the fees of the lawyer. Even if you have a legal aid lawyer, still you are supposed to travel to the courts. Then there is so much of a pressure on the litigants till the time litigation is going on, and definitely there is the sense of uncertainty. You never know eventually which way it will go. So in order to beat all that, in order to combat the adverse effect that prolonged litigations have on our litigants, especially the poor people, we needed to streamline the law. So to address all these issues, what was required was a citizen-centric criminal procedure, which is the need of this hour. So from Criminal Procedure Code in 1973 to Bharatiya Nagarik Suraksha Sanhita in 2023, what is the objective behind overhauling the law? First, to ensure fast and efficient delivery of justice. See, merely speeding up the justice delivery system while ignoring the fairness of procedure is not a very commendable thing to do. So what is required is that we have to ensure that justice is delivered fast and without compromising on the efficacy, because we need to remember that while justice delayed is justice denied, justice hurried could be justice buried. So in order to strike a balance, what is required is that justice delivery system needs to be fast without compromising on the efficiency or fairness of the system. So we need to reduce the complexity. How would that be done? When we streamline in a very systematic manner, we lay down the legal procedures. We need to reduce pendency. How can that be done? When we prescribe certain timelines, and those timelines, they need to be adhered to, whether we are talking about the police, whether we are talking about the trials during courts, all this needs to be conducted in a very time-bound manner, and for that in the BNSS, strict timelines they have been prescribed for every stage. Then we need to improve the rate of conviction. See, the offenders, they should not be having a confidence that we can get away with anything. This is a confidence which should be there in the minds of our people, that see, if somebody does a wrong, he would not be able to escape from the long arms of the law, and the law will eventually catch up with that offender. So in order to inspire that kind of a confidence, what do we require to do is, we need to improve our rate of conviction. See, improving the rate of conviction doesn't mean that we have to convict innocent people also. We have to be mindful that only those who are actual offenders, they need to be convicted. But if a person has committed an offence, we need such adequate streamlined procedures, we need such kind of technological involvement in the trial system that an accused should not, that an offender, not merely an accused who has actually done an offence should not be able to escape from the law. Thereafter, what was the objective behind overhaul of this law? Appropriate usage of technology. See, trials, inquiries, proceedings, they need to be conducted electronically, and also in absentia for proclaimed offenders, those who evade trials. See, what would happen earlier? We are not able to apprehend an accused person, the accused goes into hiding. Sometimes the accused flee jurisdiction, they travel abroad. Now what happens in such cases? We are not able to lay our hands on the offender. We are bound by the principles of natural justice that we follow. So we do not condemn a person unheard, because the person has a right to appear before the courts, present his own side of the story. So what would happen? Such people, they would take advantage of our what we call as an approach in which we were trying to protect the rights of each and every person, but those offenders, they were misusing the system. So now what the law says is, if a person has fled the jurisdiction, despite our trying to get to that person, the person is not coming back. Once the person is a proclaimed offender, then in such cases, let the person not come back, but he does so at his own peril. We will continue with the prosecution. Let the person not turn himself into before the law. The proceedings will continue, and in case he is to be punished, he would be punished in case he is found guilty. If he chooses not to defend himself, not to present his own side of the story, he is doing so at his own peril. He would be punished. If he has any properties, they could be attached. So whatever the kind of punishment could be administered to him, that would all be done. So now trials can be conducted in absentia also. And sometimes what would happen, suppose the accused is in prison. Because of lack of manpower, it becomes an arduous task to transport those prisoners to the court for every hearing. Sometimes it becomes difficult for the witnesses also to be present before the courts for every hearing. And due to this, what happens? Unnecessary number of adjournments, and the time that it takes to complete a trial, it goes on extending. So to cut down that wastage of time, now what is permitted is taking of evidences through video conferencing also. Now we can examine witnesses, now we can examine the accused persons through video conferencing also. So now we need to leverage technology in order to cut down the time that is taken while conducting trials. Thereafter, what is the next objective is? Utilization of forensic. It has been mandated for offences that are punishable with imprisonment of 7 years and above. See, a crime which carries a punishment of 7 years or more, that has to be a very serious crime. So, in such crimes, just because we do not have appropriate mechanism to get the forensic examinations done, does that mean that we will allow the accused to get away? Now, what the law says, if any state does not have proper forensic facilities, they can take the help of some other state. They can notify labs, whether it is in their jurisdiction or some other jurisdiction, as the appropriate authorities wherein such forensic tests and all would be conducted. But now it has been mandated, as far as practicable, we have to try and get forensic examinations done whenever there is a allegation of a serious crime that has been committed, which entails punishment of more than 7 years. Thereafter, the next objective is to release under trials on personal bond those who have spent half of maximum prescribed sentence in custody, and the trial is still going on. See, we need to put an end to the agony of those under trials who have been languishing in prisons for a long period of time. So, for those people who have spent half of the maximum prescribed sentence, and that sentence would be awarded to them only if they are adjudged guilty at the end of the trial. So, all this time when they are suffering in the prison, what is required? Now, what does the law say? That we have to release all such under trials who have already spent half of their maximum prescribed sentence in custody. So, such under trials, they can be now released on a personal bond. Some highlights now of the new law. So, the Bharatiya Nagarik Suraksha Sanhita, under this law, the state-citizen relationship is based on justice. The objective is to do Nyay, as is given under the new substantive law, which is the Bharatiya Nyay Sanhita. So, this is a law. See, procedural laws, they exist to help or support the substantive law. So, the objective of substantive law is justice, and what is the objective of procedural law? It is citizen centric, to protect, to guarantee protection to all our people. So, the objective of the law is to make the criminal justice system more citizen centric. Now, citizen is the pivot around whom the entire criminal justice system has to revolve. BNSS, it is not a mere procedural law. Unlike the old criminal procedure code, which was merely procedural, this is more protection based. What is this law going to do? It will lead to modernization of our legal framework, because see, law exists for the benefit of society. As the society evolves, law also needs to keep evolving. Law also needs to update itself to suit the changing needs of society. So, by ushering in this Bharatiya Nagarik Suraksha Sanhita, we are trying to modernize the entire legal framework. So, this is a law which lays down a holistic approach to deal with crimes in the digital age. In this digital age, people, they are coming up with new kinds of crimes every day, and if we stick with the old procedures, we will not be able to apprehend them. So, law also needs to evolve in order to apprehend those criminals who are using technology to commit crimes, and then to erase their footprints of commission of the crime. So, the law has to, if not be ahead of them, at least the law has to be in tune with them. Then, in petty offences now, summary trials have been made mandatory. That is, the trials are to be conducted summarily without wasting much of the time, because if an accused is being tried for a petty offence, sometimes what happens? The damage that the person has caused to a person, to another person, whether in monetary form or whether in any other kind of form, that damage would be very less as compared to the damage that we are causing to our system by those prolonged trials. Okay, so now there is so much of manpower involved, so much of energy, so much of time, money that is wasted of the state in conducting trials. So in petty offences now we have to strike a balance, and in such cases what we can do is we have to try such offences summarily. Then now even the accused can be examined through video conferencing. Then in this new law, victim has more say. Victims have to be supplied copies of first information reports. See, it is not necessary that the victim goes and register the information with the police. FIR can be registered by anyone who comes to know about the commission of the crime, but no matter who has registered the FIR, now the victims, they have to be supplied copies of FIR so that they know that, see, what is the information contained in the FIR, whether that is a truthful version, whether that is an accurate version, and whether that contains all the information regarding the crime that has been committed against the victim. Furthermore, as the investigation progresses, what would ordinarily happen? Victims, they would feel sidelined. Unless and until the state called them to testify against the accused persons, ordinarily the victims would have no say in the criminal justice system. Because in our criminal justice system, which was earlier focused on punishing the accused person, justice for the victim was not thought about. But this is a law which ensures the involvement of the victim throughout the trial process. So now what is to be done is the victim has also to be kept updated about how the investigation is carrying on. In those cases where punishment is 7 years or more, that is, again we are talking about a serious category of offences. So what happens ordinarily? Crime is an offence against the state. Crime is a public wrong. So irrespective of who is harmed, even if it is an individual who is harmed, prosecution is to be initiated by the state. So it is totally between the state and the accused, and sometimes what happens? The state is compelled by circumstances. Sometimes the state has to decide to drop prosecution. But now what the law says, that it is not in every case that there would be this absolute discretion with the state. Now, if the prosecution has to be dropped in those cases where the punishment that is carried for that crime is more than 7 years, then in such cases, victim would have to be necessarily heard. And if the victim is not okay with the state withdrawing from prosecution, then that would have to be considered by the courts before it takes a decision in this regard. So you see, again, this is a way in which we have tried to inspire confidence in our people that, see, now this crime thing is not only between the state and the accused. The victim is an equal and an integral component, an integral part of this entire system, and the victim should feel that, yes, the wrong that was done against me has been undone or minimized, or at least some justice has been done to me. Then another very positive highlight of this new law is the witness protection scheme. The witness protection scheme, it has been introduced in the statute by virtue of section 368 of the Bharatiya Nagarik Suraksha Sanhita, that says, now every state is mandated to prepare and notify a witness protection scheme. So now it is no longer a discretion with the state. Each and every state has been mandated to first prepare a witness protection scheme, and then you need to notify the same. So what is the witness protection scheme? In criminal justice system, witnesses, they are the eyes and ears of the criminal justice system. So witnesses, they should feel secure. Witnesses should have this kind of a confidence that if we are trying to help the investigation, if we are trying to depose before the courts, we are to be protected by the state. Earlier, anyone who wanted to help the criminal justice system by deposing against the accused person. Now those people, they would do so at their own peril, because we did not have a proper system in place, due to which what would happen, witnesses, they would be threatened by the accused persons or their family members. Sometimes they would be subjected to some sort of a harm. So they would stay under some kind of a constant fear. But what is required is that when somebody comes forward to help the state, is it not the responsibility of the state to ensure that those people, they are protected? So that is what the witness protection scheme is all about. So in the year 1958 itself, for the first time, the Law Commission in its 14th report had mentioned the need for a witness protection scheme in India. Thereafter, it was followed up in the 154th, 178th and 198th reports also, and it was re-emphasized that we need to develop a witness protection scheme. In 1980, the 4th National Police Commission had noted in its report that prosecution witnesses are increasingly turning hostile. And why would that happen? Initially, a person would agree to be a prosecution witness, but later on, they or their family members, they would start receiving threats from the accused persons. So people would feel that why should we jeopardize our own safety or those of our family members in order to help the state, and the state is not doing anything for us. So what was required was that we needed to protect our witnesses, and towards this end, in 2006, one provision was introduced in the then IPC, and that provision was section 195A. And that provision, it made criminal intimidation of witnesses a punishable offence. Thereafter, in 2018, MHA, Ministry of Home Affairs, proposed a witness protection scheme, and they had prepared that scheme in consultation with NALSA and BPRD. And there was the Supreme Court judgment of 2018, that is Mahinder Chawla versus Union of India, in which the Supreme Court had declared that witness protection scheme shall be the law. The witness protection scheme that was drafted by MHA in consultation with NALSA and BPRD. So that witness protection scheme shall be the law till the time the Parliament or state legislatures prepare and notify their own witness protection schemes. So let us talk about some more highlights of the BNSS. Now, during search and seizure operations, videography has been made mandatory. See, many times citizens, they would feel that police has been given lots of powers, and due to which what happens, sometimes the police forces, when they conduct search and when they conduct seizures, people, they accuse the police of rather planting some evidence in order to falsely accuse a person. So now, in order to bring about more transparency in this system, in order to inspire confidence amongst our people that no, you would not be wronged, and at the same time, in order to inspire confidence in our righteous police officers that nobody would be hurling unnecessary allegations against you, in order to ensure a total fairness and transparency of procedures, what does the law say? That now, whenever search and seizure operations are to be conducted, we need to videograph the same. Although this is one provision in which there are certain concerns regarding privacy as to till what extent, when we are conducting personal searches, at that time also is videography to be mandated. Now these are things over which maybe we would need certain more clarifications, and maybe we will have to wait to see how the judiciary deals with these kind of questions. Till that time, at least there is one positive thing, that whenever any search is being conducted, there is a videography that has been mandated now by the law. Next highlight of the BNSS is the focus of the law. Now what is the focus of the law? Focus of the law is to expedite the criminal justice system. How can that be done? That can be done if we effectively clear the backlog, the pending cases when they are disposed of. So, what do we need to do? We need to make our criminal justice system more efficient. See, when procedures are complex and when those procedures, they instead of making the system easy, they complicate the system by impeding justice delivery, then in such cases what is pertinent is we need to amend the law. So, that is crucial. Now, this new law, it defines what our audio video electronic means. In this age of technology, when so much of technology is being utilized, it is everywhere. We all have mobile phones in our hands. We are working all the time on computers. So, in such an age, we need to clearly define what our audio video electronic means, what amounts to electronic communication, and we need to utilize this technology for collecting evidence and evidence in all forms. This new law, it also makes provisions for zero FIR. It has provisions for EFIR. So, now you can register an FIR at any place, irrespective of whether there is a jurisdictional issue. The police have been now directed to register an FIR. An ordinary person doesn't know what the jurisdiction issue is, but the police knows. So, what you are supposed to do? You are supposed to give the information, the police will register the information and they will themselves transfer it to the place where there is an adequate jurisdiction. Sometimes you are not able to travel to the police station, you can register an EFIR. Then at your convenience, as early as possible, you can just go and further put your signatures on that FIR. But at least immediately you are putting the criminal justice system in machinery before the accused gets a chance to run away. Then strict timelines have been imposed. Criminal trials, they are to be completed in 3 years. We all know that criminal trials in our country, sometimes they take 10 years, 20 years. We need to cut down on that. There has to be an end to the trouble that litigants face during those trials. There has to be a certainty in the minds of the accused persons also, that whether I am to be convicted, whether I am to be acquitted. So, what is required is that there has to be a strict timeline for completion of trials. And now what does the law say? 3 years, complete a criminal trial. Thereafter, once the trial has been completed, judgments, they cannot be reserved for longer than 45 days. The judges, they have to pronounce their judgments within 45 days after the conclusion of arguments. To cater to the demands of our contemporary times, all trials, all inquiries and all proceedings, they may be conducted in electronic mode. See, when we had this unfortunate COVID situation, that was the time when we realized that technology could help us so much. All this time when we were blaming technology for all the problems that it had created in our lives, COVID was a time when we appreciated the usage of technology for making our lives easier. Now the technology is not going to make it easier only for criminals to commit a crime. This technology is also going to help our criminal justice machinery for apprehending, trying and punishing those criminals. Now this is going to combat all issues related to delay in examination of witnesses, delays in conducting of trials, overcrowding of prisons, issues relating to under trials languishing in prisons. So, all this and more would be taken care of by the new law. And to deal with problems relating to absconders, now what the courts can do? Courts can now pass conviction orders against them in absentia. In their absence also, they can be now convicted. So, now let us talk about the provisions of Bharatiya Nagarik Suraksha Sanhita. Section 1 of the law, which is short title, extent and commencement. So, this is an act which may be called the Bharatiya Nagarik Suraksha Sanhita, a law which is citizen centric, a law that focuses on the protection of its people. So, the law is more of a protection based law instead of being a merely procedural law. So, this act may be called the Bharatiya Nagarik Suraksha Sanhita 2023. the provisions of the Sanhita other than those relating to chapters 9, chapter 11 and chapter 12 thereof shall not apply. So, what are these 3 chapters? Chapter 9 deals with security for peace, keeping the peace and good behavior. Chapter 11 is maintenance of public order and tranquility, and chapter 12 deals with preventive action of police. So, these 3 chapters taken together, see these 3 chapters, they are to be implemented throughout the territory of Bharat. Any place cannot be excluded from the implementation of these provisions. Why it is so important? Because sometimes a person who has the capability, or when we have some kind of information that this person has the propensity of committing a crime, such person needs to be detained in order to prevent the commission of crime. Sometimes we have to order dispersal of unlawful assemblies which have the capability of translating into some riots or some crimes that might be committed in furtherance thereof. So, the police sometimes needs to take preventive action to prevent the commission of such crimes. So, these provisions which have been given under these 3 chapters, chapter 9, 11 and 12, they would be implemented throughout the territory of India, but otherwise other provisions they shall not apply to the state of Nagaland, to the tribal areas, but the concerned state government may by notification apply such provisions or any of them to the whole or part of the state of Nagaland or such tribal areas as the case may be, with such supplemental, incidental or consequential modifications as may be specified in the notification. So, states may issue their notifications, they might implement this law in part, they might modify certain parts. So, depending upon what are the peculiar needs of that particular state or the tribal areas that this law is talking about, there also this law can be implemented, but subject to the state modifications. Then what is the explanation to this provision, which explains in this section, tribal areas mean the territories which immediately before the 21st day of January 1972 were included in the tribal areas of Assam as referred to in paragraph 20 of the 6th schedule to the Constitution, other than those within the local limits of the municipality of Shillong, and the law shall come into force on such date as the central government may by notification in the official gazette appoint. So, this law, it has been notified to be implemented with effect from 1st of July 2024. Now, let us talk about the definitions of various terms. Once we are clear about how any term is to be construed when we are studying the procedural law or when we are talking about the Nagarik Suraksha Sanhita, so then it will be very easy for us to understand the provisions. So, there are some provisions which have been introduced for the first time in the BNSS. Before 2023, these terms they were used at some places in the law, but how do you define them? That was not given anywhere in the law. So, now all these terms they have been defined. The first definition is of audio video electronic means. Now, this is a term which finds place for the first time in our Nagarik Suraksha Sanhita. What does it say? Audio video electronic means shall include use of any communication device for the purposes of video conferencing, recording of processes of identification, search and seizure or evidence, transmission of electronic communication, and for such other purposes and by such other means as the state government may by rules provide. So, you see this is such a broad based definition. It says any communication device that is used for the purposes of video conferencing. See, we use mobile phones, we use computers, we use different softwares for video conferencing. So, audio video electronic means shall cover all those. Then whether we are recording the test identification parades, whether we are recording search and seizure of evidence, transmitting that electronic communication. So, all that would be covered within the definition of audio video electronic means. Then the next definition is regarding the term bail. See, we all have heard this term bail, but what does the term bail mean? Till date, this term did not find any definition. It was mentioned at multiple places in the court. It is something which we all use. Okay, I need to be bailed out of this situation, and in legal terms also we are using this term that okay, this person, did he manage to secure bail or not? We have heard that there is anticipatory bail and all. But what exactly does this term bail mean? So, for the first time it has found a definition in the Bharatiya Nagarik Suraksha Sanhita. And what is bail? It means release of a person accused of or suspected of commission of an offence from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or a bail bond. Now, see, if a person is suspected, the police can apprehend that person. If a person is accused by another person and there are substantial grounds for believing that okay, the accusation might have some merit, the person might be apprehended by the police. But then see, as long as the person is not convicted by a court of competent jurisdiction, that person has his right to life and personal liberty. So, if we have arrested that person, so now that person might have a right of being released from that custody. That all depends upon the classification of offence of which he is accused. If he is accused of a bailable offence or a non-bailable offence. But what is the meaning of bail? It means if a person has been accused or if a person is suspected of commission of an offence and that person has been taken into custody, then if bail is granted to such a person, the person would be released from the custody, and this is a conditional release from custody. So, what does that mean? Why does the police arrest or apprehend a person? The objective is simple, so that the person may cooperate with the investigation, so that the person may not tamper with any evidence, the person may not try to influence any witnesses, the person may not try to hinder the investigative machinery. That is why sometimes we need to take a person in custody in order to ensure that the person does not flee from justice. So, when bail is to be granted to a person, certain conditions are to be specified in that bail order. Let us see, you have been released from the custody, but subjected to these conditions that could be mentioned. So, bail means release of a person accused of or suspected of commission of an offence from the custody of law upon certain conditions that are imposed by an officer or court on execution by such person of a bond or a bail bond. Now, what is a bond and what is a bail bond? Again, these are terms which we have heard very often, but the meaning that is assigned to that term under the law, that was not clear till date. So, now these two terms have also been defined in the Bharatiya Nagarik Suraksha Sanhita for the first time. So, what is the meaning of bail bond? It means an undertaking for release. So, first there has to be an undertaking for release and it has to be with surety. Now, somebody has to stand as a guarantee for your release. Okay, and that person should be ready to give some amount of money in case you jump the conditions of that bail, in case you do not abide by those conditions. So, what is a bail bond? It means you have furnished an undertaking to the police or to the court, wherever you are securing the bail from. So, when you have furnished this undertaking for your release and that is accompanied along with surety, that is what is bail bond. And further, the law makes it clear what is bond. Bond means a personal bond. It could be a personal bond, that is when you are yourselves willing to fill a bond, or which is an undertaking. You have given an undertaking on your own, on your person, that is, you are willing to furnish that amount, or it could be an undertaking for release without surety. So, see, there was a judgment by the Supreme Court in the year 1978, Motiram versus State of Madhya Pradesh, in which the court had held that monetary bail is not an indispensable element of criminal procedure, and bail covers both release on one's own bond and release with or without sureties. See, every person has a right to be released on bail unless the person is accused of a non-bailable offence, in which case grant of bail is a matter of discretion, it is no longer a matter of right. But where a person is to be granted bail just because a person is not in a position to furnish sureties, does that mean that person will not be granted bail? So, such persons, they can be released on personal bond also, and that is what has been now incorporated under section 2 clause E by defining the term bond, which means a personal bond or an undertaking for release, and it could be without surety. Now, section 2C, what is a bailable offence? So, bailable offence means an offence which is shown as bailable in the first schedule, or which is made bailable by any other law for the time being in force, and non-bailable offence means any other offence. So, whether an offence is bailable or non-bailable, how do we know? See, it is not for us to apply our discretion and just come to an assumption that just because this is an offence which is not more serious in nature as per our own subjectivity, so this should be made as a bailable offence. No. The law has already taken note of this fact, and there is a list of offences appended to the BNSS. It was earlier there in the CRPC also in schedule 1, which lays down a total list of what is the nature of an offence, whether the offence is bailable, whether the offence is cognizable. So, all that has been already laid down. So, whenever we need to find out what is the nature of the crime, whether it is a cognizable crime, whether it is a non-bailable crime, we need to refer to schedule 1 appended to the BNSS. So, bailable offence is an offence which has been shown as bailable, and in a bailable offence, bail is a matter of right. A matter of right, that is, whenever the accused is prepared to furnish bail, furnish surety that is demanded of him, either before the court or in front of the police officer, so that person would be entitled to be released on bail, because bail is a matter of right in bailable offence, and non-bailable offence means any other offence. So, now when we say any other offence, it means an offence which is not a bailable offence, but does that mean that in non-bailable offence bail is not to be given to a person? The answer is no. In non-bailable offences also, bail may be granted to a person, but in non-bailable offences, bail is not a matter of right. In non-bailable offences, bail is a matter of discretion, and this discretion is to be exercised by the courts, and that too in accordance with certain well-established principles, that is, whether the accused needs to be enlarged on bail or not. So, it is a matter of discretion. The next definition is charge. So, whenever we talk about charge against an accused person, what do we understand by that? The law simply defines it. It says charge includes any head of charge when the charge contains more heads than one. So, it means whether we are talking about a singular charge or whether we are talking about a plural charge, the term charge would be applied. It would not say charges. Charge in itself is sufficient to cover whether it is a single charge or whether there are multiple charges. But what essentially is charge? So, charge is a formulation, a formal formulation of accusation or allegation against an accused person. See, every accused person has a right to defend himself. But how is the accused supposed to defend himself if he does not know what exactly is he being tried for? So, what exactly is the charge against him? He needs to know that. So, in legal language, what is the formal accusation against him? What is the provision against which he is being charged? What is the title of the offence for which he is being tried? Whether he is being tried of theft, whether that is extortion, whether that is robbery, whether it is dacoity. So, in clear, precise terms, he needs to know what he is being tried for, so that he can prepare his defence accordingly. So, that is why preparation, formulation of charge is very, very integral. Till the time an accused is not aware of the charges against him, he is not able to prepare his defence properly, and if charges are not properly formulated and a person is accused, in such cases non-proper formulation of charges can be a ground for vitiating the entire trial. Because see, while we are focused on punishing the accused, at the same time we cannot ignore the rights of an accused which have been guaranteed under our constitution. So, that is why he needs to have a due notice of what are the allegations or accusations against him. Next definition is of cognizable offence. So, what is a cognizable offence? Cognizable offence means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. See, cognizable offence are considered to be more serious offences in which the police is supposed to act promptly and apprehend an accused person before the accused has the chance of running away from justice. So, before the accused can do further harm, immediately the police goes and arrests that person wherever required, or the police starts investigating the process, and even for conducting arrest, the police does not need to first secure a warrant from the magistrate. See, in non-cognizable offences, you cannot arrest a person till the time you first have a warrant from the magistrate. So, now how do we determine whether an offence is cognizable or non-cognizable? Again, it is not for us to see that okay, this is a very serious kind of an offence as per my interpretation of the law, so it should be definitely a cognizable offence. No. The answer has been provided in Schedule 1 of the BNSS, where this entire table has been laid down, which lays down the classification of offences. So, now the offence might be bailable, cognizable, whatever is the classification of the offence that has been already determined by our lawmakers. So, in the first schedule, those offences which are categorized as cognizable offences, in those offences the police officers, they do not need to first obtain a warrant. Wherever necessitated, they can arrest an accused person even without obtaining a warrant. Then there are certain special laws also in which the police also needs to make arrest. So, in that also, whether sometimes what happens that the punishment which the offence usually carries, it might be less than 3 years. Ordinarily, we apply this kind of a broad test that whenever the punishment that an offence entails is more than 3 years, it should be a cognizable offence. But that is not an hard and fast rule. In certain special laws, what happens, the punishment prescribed might be say 6 months, but the offence might be categorized as a cognizable offence. That is why I repeat it again, that in cognizable offences, whether an offence is cognizable or not, that is whether the police have the right to arrest without a warrant or not. How do we determine that? By referring to Table 1, by Schedule 1 of BNSS, and also by going through carefully from the language of the special statute, wherein it has to be expressly mentioned what would be the nature of the crime, whether it would be cognizable, non-cognizable, bailable or non-bailable. So, cognizable offence, an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without a warrant. Coming to the next definition, complaint. So, complaint means any allegation made orally or in writing to a magistrate. See, FIR is to be made to the police officer and complaint it is to be made to a magistrate. So, complaint is an allegation. How is a complaint to be made? It can be made orally. Then what does the law say? It can be made in writing. So, any allegation, whether you make it orally, whether you make it in writing, but complaint has to be made to a magistrate. And what is the objective behind making a complaint? The objective is that the magistrate should take action under this Sanhita, and that some person, whether known or unknown, has committed an offence. See, sometimes we know who has committed the offence, sometimes what we know is just that an offence has been committed, but we do not know who the offender is. But what does that mean that we will not make a complaint to the magistrate? See, if you know that a crime has been committed, you are supposed to make the information irrespective of the fact whether you are aware of the identity of the offender or not. So, you can file for some information also, and you can also submit a complaint before the magistrate. So, what does the law say? How it defines complaint? Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this Sanhita that some person, whether known or unknown, has committed an offence, but does not include a police report. Explanation: a report made by a police officer in a case which discloses after investigation the commission of a non-cognizable offence shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complainant in such cases. Then the definition of the term electronic communication. It means the communication of any written, verbal, pictorial information or video content that is transmitted or transferred whether from one person to another or from one device to another or from a person to a device or from a device to a person by means of an electronic device including a telephone, mobile phone or other wireless telecommunication device. So, here you see there are certain devices that have been mentioned. This list is illustrative, it is not exhaustive because it is clear from the language, because what does it say? By means of an electronic device including. So, this could be these devices, it could be any other device also. See, we need to keep these definitions very broad, and at the same time we have to keep room for new technological innovations also. So, by telephone, mobile phone or other wireless telecommunication device, or a computer or audio video player or camera or any other electronic device or electronic form as may be specified by notification by the central government. Next definition is of High Court, which means in relation to any state, the High Court for that state. See, every state has its own High Court. In relation to Union Territory, to which the jurisdiction of the High Court for a state has been extended by law, that High Court. And in relation to any other Union Territory, the highest court of criminal appeal for that territory other than the Supreme Court of India. So, students, in this lesson, I tried to give you an overview of the new law related to criminal procedure, which has now changed from CRPC 1973 to BNSS. We discussed the highlights of the new law, what are the objectives of the law, and why was this change necessitated. Okay. So, we also tried to cover some of the important definitions. In the next lesson, we will try to cover the remaining definitions, and at the same time we will also try to understand who are the various functionaries and stakeholders in our criminal justice system. So, that will be all for this lesson. I hope I could make my points clear. Thank you.